Hey, everybody. Welcome. Happy Wednesday. Um, I'm Lori Hellis. I'm a retired criminal attorney writing a book about the Daybell case. And boy, do I have book news for you all. The pre-order links are up, and you can find the order link in our show notes. I want to just thank everybody who's already pre-ordered. The response has been overwhelming. The book will release on September 3rd. It'll be on the shelf, which was a little earlier actually than I expected. I expected October, so I'm very excited about that. My editor is very excited about the book. It's an interesting way that they're set up. Pegasus Books is an independent publisher, but they do all of their distribution and marketing through Simon & Schuster. So they had to present the book cover and the book, the concept, to Simon & Schuster. And they got very, very positive remarks back. They were all very excited about it. So that was exciting to me, and really validating to me that everything's coming along. So Chad's trial starts in April, and I'm going to be covering that and then updating the manuscript before it goes to absolutely goes to press in June. And then from there, the book will go to print and ship out to be on the shelf on the 3rd of September. So super excited about it. Thank you so much for all of you who have been so supportive, to the folks who read some early chapters and gave me great feedback. And I just am super grateful to everybody, because in a lot of ways, it's a funny thing. Because on one hand, writing is a really solitary pursuit, but on the other, it really takes a village to write a book. So I am really excited. Thank you so much for the folks that I see in the chat who are all saying they've pre-ordered their books already. Pre-orders are very important to authors because it really shows the publisher the interest in the book. So I do want to talk a little bit about what you all can do to help. I am going to make available, I'm going to invite the first 100 people to join my book launch team. And what that means is you sign up to be part of the book launch team, and we will give you an advanced digital copy of the book before it's actually goes to press, so that you can read it and you can post reviews. Reviews are super important, and they are particularly important on Amazon, because if I get to 60 reviews, they start promoting the book on Amazon. It goes into the ad funnel. So I'm looking for folks who are willing to sign up on a separate website and be part of my team. And what that means is you will get an advanced copy of the book. You will get access to some other events and things that'll go on for the book launch team. And your part of it is to post a review of the book and to post on social media. Once you get a copy of the book, once you get your copy of the book, then post on social media, so that we do lots of social media pictures of folks from all over the world with books. So what I'm waiting on is I'm waiting to hear from my IT guy who is helping me overhaul my website and create the website for the book launch team. So that, I hope, is going to happen in the next week or so. What I plan to do is I will put that out in a newsletter to the 5,000 folks who are on my newsletter list. And then by next week, I hope we'll have a link, YouTube link as well. So we'll put it out to everybody, and the first 100 folks will get an advanced copy of the book digitally. and some other perks and bennies. We are also deep into planning for CrimeCon. So anybody who is going to CrimeCon, if you have any interest in showing up and helping man my booth for a couple of hours while you're at CrimeCon, please drop me a message either in the comments or you can DM me through Facebook, and let me know if you'd like to hang out behind the desk for a couple of hours during CrimeCon. And don't forget that CrimeCon does use volunteers. So if you are interested in a free pass to CrimeCon, there are links in our show notes of where to go to apply to be a volunteer. CrimeCon is in Nashville. It is May 30th through June 1st. That's the Memorial Day weekend, I believe. And I've never been to Nashville, but it sounds like it's going to be a blast. So that's the book news so far. And I couldn't be happier with the way it's going. One of the things we talked about doing for a while was doing a quilt for Kay and Larry Woodcock, JJ's grandparents. And my idea was, in Japan, people often fold origami cranes as a memorial for someone who has passed away. And they always talk about the importance of folding 1,000 cranes. It's a very contemplative activity. And I did a memorial quilt for a friend with cranes, and it was very meaningful. So I have now, my idea was that I would produce or make available a pattern, and anybody who wanted to could create a crane square, send them to me, we'll put them together in a quilt for Kay and Larry. So the pattern is now a link in our show notes, and here is the square. The lighting's not great. This one's sort of a pale pink. I'm gonna pull this down so you get the whole view. There we go. And a black background. So the only thing I have said is please make your background black. It doesn't matter what kind of fabric it is. Just a basic quilter's cotton is great. And these are foundation paper pieced. I am going to make an instructional video on paper piecing for those who might not be that familiar with it. I actually love it because it makes for a very accurate design. So you can see the back of the piece, I still have the foundation paper pieces on. So what you do is you use that as a pattern and you sew over the paper, and it creates these very nice sharp angles. So if you would like, you can go to the link in the show notes. It will link you to a Google document where a PDF of the pattern is. These are 6-inch squares, and you can send them to the address where you also send for wristbands. I will do an expanded video and post a little bit more instruction this week, but that's the next thing. Once I have all your squares, I'll assemble the quilt and we will send it off to be quilted. And hopefully Terry Goyens can do that for us. And we will make it a gift for Larry and Kay. So somebody is asking about audiobook. My understanding is that the book will be made into an audiobook. Now, my publisher has not had a conversation with me about doing the voiceover for the book. And frankly, most authors don't. So I don't know when and how that will happen, but it will happen. And it usually happens pretty quickly after the book hits the shelf. So I would think the audiobook should be available right around the same time as right around September 3rd. the same time as the hardbound book. So, and it did come out in hardbound, which is really kind of cool. Not all books come out in hardcover these days. An awful lot go directly to paperback. But my editor was very adamant that she felt this was what they call an upmarket book and that it needed to come out initially in hardcover. So that's pretty cool too. So we have a bit to talk about in the true crime realm. And I want to start out with the case that's near and dear to our heart, Lori and Chad. Chad had a hearing scheduled today. And I'm not really sure whether it happened or not. When I got on Judge Boyce's YouTube channel, it didn't come up. I suspect they may have done things in chambers because I think there were perhaps some, I know they were going to be working on juror questionnaires and the sorts of things that you would usually do in chambers. So it may have happened, but it may not have been live streamed. I wanted to point out that Scott Reich put out, for those of you who watch his channel, said on his channel that Chad was seeking a continuance, and that's not accurate. Now, I know Scott's really busy, and he's got a couple of people who keep him up on things. So it's not just Scott. But sometimes if he's very busy, he's got somebody who's watching all the channels and watching the news and all the news feeds and compiling the information for his show. And, sometimes a person who's not a lawyer might misunderstand or misinterpret what happened. So I think that's what happened with Scott, giving him the benefit of the doubt. But what happened was John Pryor filed a motion asking for extra time to produce their expert witnesses and their reports. That's all part of the pretrial process. So many days before the trial, you have to tell the other side who your experts are and what they're going to say. And if you're going to try and introduce written reports, all of those things have to go ahead of time. So what Chad said was, what John Pryor said was that the state had given him what he contends is new discovery. And he wanted more time to be able to, in case he had to have his expert review any of that discovery. The prosecution says there's nothing new. It's all stuff they've gotten before. So we're not sure at this point what the judge is going to do with that motion. He may have heard, it may have gotten resolved today, and we may just not know it. But I know at the last hearing, the judge said one of the things they were going to do at today's hearing was work on jury instructions. So I suspect that's probably why we didn't see a live stream. But it was a big day for both of them because Lori Vallow had a hearing too. It's interesting. If you get a chance, it's very short. I think Nate Eaton has it up on East Idaho News. There's a couple of other places that have it up. It's very short. And, at some point when I'm not deep into figuring out how to market my book, I want to get to the point where I can pull video clips up for you, but I just haven't perfected it yet. So, but the hearing's very short. It was out there. It's basically a pretrial hearing. The defense announced that they have gotten something 20 plus terabytes of information recently. The defense attorney said it's the equivalent of 88,000 pages of discovery. So he said that they, they're still going through that discovery and that they are getting through it as best they can. So the interesting thing about the hearing, and the judge said, well, your trial date might not be realistic. Now, Lori has not waived speedy trial, and I don't think she will. So I think it is a realistic date, because I think she's going to go to trial come hell or high water. So, but the most interesting thing was Lori's demeanor in court. She came in, kind of had a bouncy little walk. She was kind of bubbly, kind of flipping her hair, walked past the prosecutor's desk, said hi in her little voice, and and sat down at counsel table. She was between her two lawyers, a woman who doesn't have any hair, so I think she must be undergoing cancer treatment, and a man. She definitely spent more time talking to the man than the woman. Barely acknowledged that the female attorney was there, but boy, she was hanging on every word with the male attorney. Kept turning around over her shoulder where she knew the camera was and making eye contact with the camera, and definitely looking totally relaxed, totally in control, laughing, giggling, bubbly. And I thought that was really interesting, that she's at least putting on that facade that she's just fine. So the next hearing date for Lori is the 24th of April. The judge wanted to give the defense time to sort through all that discovery. So the 24th of April at 8:30, and they asked for Lori's appearance to be waived. That is not uncommon in these kind of scheduling hearings. For one thing, leaving the jail, it is really a hassle for the defendant, for the inmate. You have to be strip search going out, strip search coming back in. I mean, often what happens is you get to court, you're there for a 5-minute hearing, and then you sit around until the transport goes back. So it could be several hours that you're sitting in a holding cell. And it doesn't make any sense for these kind of brief hearings. If they wanted to, I'm sure that the judge would allow her to appear by video, and that way she could appear from the jail and wouldn't have to go through all that falderall to get to the courthouse. So her appearance for the next one was waived. She still has a September 1st trial date looming out there. And so it will be it will be coming up before we know it. And then I wanted to talk about Chad Dorman. Chad Dorman is the father who murdered his 3 sons, his 3 little boys. And the police arrested him. He didn't put up a fight and went to jail. And we haven't seen much of him. My understanding from what I could see online was that he was undergoing a mental health evaluation and some other screenings. However, he was in court today. There were a couple of motions to suppress and a motion in limine that were heard today. And the judge took all those under advisement and did not make a decision. But we did hear a bit from the police officers who were the first on the scene. Now, we have seen the body camera, the body film from their cameras when it happened. So we kind of have a pretty good idea, although they fleshed it out a bit with their own personal experience, because there were things that were either edited or were blacked out in the body cam footage. Their contention was that he had not waived his Miranda rights, and that conversations that he had in the jail with the mental health staff should have been covered by HIPAA. So the prosecution made the argument that there is a specific exception in the HIPAA law for people who are in jail, and also as an exception for the mental health provider. What they did, the officers came and testified about their interactions with Chad Dorman, including their interrogations of him. But they also gave the judge a thumb drive that had all the body cam footage and the interrogation footage on. And the judge said he would watch those and then he would make a decision. So I suspect, now I have not seen the interrogation film, but the officer says he did give him his Miranda rights. Dorman was a little bit vague. At one point, he said something about, maybe I shouldn't talk until I get a lawyer. I think you guys should just give me a couple of days and I'll talk to a lawyer. It's kind of intimating that they should just let him go. Well, that wasn't going to happen. And so, the judge said he was going to take it under advisement, and after watching all the footage, he would make a decision. That one is set for trial. I think it's September. I didn't write it down, and now it escapes me. So, and then finally, I wanted to talk about the Montgomery case. We talked about it quite a bit last time, about the issues of, did the state of Massachusetts mess up? Yeah, they did. And kind of we talked a bit about the process for how kids come into child welfare custody, what happens after that happens, and then what the state of Massachusetts could have done, didn't do, when Adam Montgomery was given custody of Harmony. I listened to the closing arguments today. Both gave their closing arguments, and we're on verdict watch in that case. So I suspect we will get a verdict tomorrow. They started late in the day, and so I suspect that they'll get back to it tomorrow. The closings were interesting. The defense attorneys essentially said Adam loved Harmony. He would have never hurt her. It was all Kayla's fault. Kayla was Adam's wife, Harmony's stepmother. The prosecution then really kind of tore that theory apart, really went through it step by step, said that he fought to get her, but it was because he wanted control and because he wanted money. And they said the whole Kayla did it is a very kind of tortured reasoning, and it didn't make a lot of sense. One of the really moving lines that the prosecution said was, Adam became more and more desperate. They were both drug addicts. They were both receiving methadone doses at the methadone clinic. They additionally, they were still both using. And once they were evicted from the home they'd been living in, Adam just became more and more desperate. And the prosecution said he lost things until all he had was his car, his rage, and his fists. Really, really, that case is tragic. You all know I raised a little blonde girl that wore glasses, looked an awful lot like Harmony, and it is a really tough case. I suspect that they're gonna come back with a verdict pretty quickly. But one of the things I wanted to talk about tonight is Kayla. Is she complicit or is she a victim? And I'm kind of interested to hear what you all have to say about that. So, I'd love for you to post your comments in the chat over here, over there. So weird that it's backwards. The image is backwards. But I definitely would like for you to post in the chat and let me know whether you think Kayla is a victim or whether she is complicit. There's no question that she committed perjury. There's no question that she participated in some way in disposing of Harmony's body. However, and I think that the things that she did were really horrible. But I also, back when I was practicing, I tried a couple of cases and I realized there were cases involving sort of the irrational things that that drug addicts do. One particular case was kind of a he said, she said among a group of meth users. And in order for me to explain this to a jury, I had to say, understand that these people live in a different world than most of you do. They live in meth world. And in meth world, things that make no sense to us make perfect sense. Like getting in a car in the middle of the night and driving off to find some homeless guy out on BLM government land, out in the Tules, out in the wilderness, because you heard he might have some drugs and he's homeless and he might be willing to give you a good deal. And there you are at 3 o'clock in the morning, driving around in somebody's beat up SUV, looking for a homeless guy who's camped out on the government land. These are the things that people in meth world do, people in drug world do, that make no sense to us. And they live hand to mouth and they eat fast food and their cars die in the middle of intersections. And I mean, these are common occurrences within that drug culture. And they are broke and they find a few dollars here or there. And I think that was the world that they were living in. In addition, Adam Montgomery was a very violent and very controlling man. You heard that from Harmony's mother, and to some extent, you heard it from Kayla as well. I don't think that Kayla's ever completely gotten over Adam. I think she would still like to be with Adam. But I think that we have to look at her and think she may be a victim too. A victim in terms of her not being more assertive and not reporting Adam and helping him hide Harmony's body and all of those things, really because she was afraid of him. And it's hard to explain that fear is is so deeply ingrained in someone who has been physically abused by their spouse that it's almost not conscious. It's almost a subconscious sort of giving in or protecting or deferring to somebody like Adam. They showed pictures at trial of Kayla all beat up because she supposedly didn't want to help Adam. I mean, you know, ultimately it's a he said, she said sort of situation. Kayla clearly got a good deal from the prosecution and was not charged with Harmony's murder in return for her cooperation. But I don't know if that makes her any less credible. She's not a nice human. She's not a good person. She didn't stop Adam from beating Harmony to death. But on the other hand, she also was fearful. And also, I mean, think of it this way. He'd beaten her before, and she had watched him beat his child to death. If that's not a scary guy, I don't know what is. And I think for Kayla, it was I don't want to run the risk of getting hurt, getting killed, or of him taking her children. That was, I mean, I'm not going to advocate that. I'm not going to say that was a good choice. I think it was a terrible choice. I think it's understandable, but I certainly don't, I don't think it's excusable. Hopefully that makes sense. I think you can understand why Kayla felt that way, or where she was coming at from an emotional standpoint. Let's remember, she's not a very sophisticated person, perhaps not very bright, and also addicted. So all those addictive behaviors on top of that. I mean, I abhor the choice that she made, but I would be remiss if I didn't point out to you all that I have known a lot of Kaylas in my life, and I have known a lot of people like her. And I guess there is at least for me, a little bit of an understanding of maybe why. I think that Adam Montgomery is a horrible person, and I think that I think he is an incredible coward not to come to trial. And I think that it was a mistake on the part of the court to allow him to do that. We don't know what the reason was for the judge deciding to allow him to skip the trial. We don't know. And it may be that the judge was concerned that it would be a safety issue, or it would be an issue of controlling him while he was sitting at the witness stand. I mean, we all saw 3 or 4 weeks ago, the guy that was getting sentenced who lunged himself across the over the bench and went after a judge. So those things do happen, and perhaps the judge just thought it wasn't worth the risk of forcing him to be there when he wouldn't leave his cell. So there are not a lot of updates in a lot of other cases. Now, I've had so much on my plate. I have not followed the Michelle Troconis trial down in Florida because I didn't have the bandwidth for it, frankly. So, but that trial is still going on. I think it's in its 7th week. It's been going on forever. And I don't even know if they're close to finishing. So the premise is that Fotis Dulos murdered his wife, Jennifer Dulos. Her body's never been found. and that Michelle Troconis was Connecticut, yeah, was an accessory to that crime. That she assisted him in disposing of the body. There's camera footage of him driving around in his car and throwing trash, garbage bags in dumpsters. Her body hasn't been found, so that makes it even harder to prove a murder case with no body. And Fotis Dulo unalived himself. So the only person who's left is Michelle Troconis, who was Fotis Dulo's girlfriend. And, you know, as I say, I have not been following the case closely, but I've wondered all along whether they really have enough evidence to actually connect her to the murder. What I've seen of it makes me think they may not, but they may, the jury may be able to make the connection to some sort of conspiracy or aiding and abetting. So there's that. We haven't heard much on Donna Adelson recently. She recently made a quick appearance. She appeared by video and from the jail, and that hearing was just sort of a status hearing. So we're still waiting to find out when her trial date will be. I think, if I remember correctly, they had asked the attorneys to come back with their calendars and try and set a date, but I could be wrong. And finally, I want to talk about Frankie and Hildebrandt. Ruby Frankie was the Mormon mom blogger who had a blog called 8 Passengers that had at one point had over 2 million subscribers. And Jody Hildebrandt, who was her therapist. They were both, they were accused of having abused and tortured Ruby Frankie's 2 youngest children as a form of discipline. And Jody Hildebrandt was a therapist who claimed that those sort of tactics were the most helpful for children. They were both charged with 6 counts of felony counts of child abuse, and they both pled guilty to 4 of those counts in a plea agreement. And the next thing that happened was they were convicted, and we just had sentencing yesterday. Ruby Frankie got up and made a very heartfelt statement. Her attorney got up and made a very heartfelt statement saying that she that she loved her children, that she loved her husband, that she regretted everything that she had done, that she lost sight of the truth, lost sight of the of what was real, of reality, became extremely paranoid, all because of Jody and what she was saying and what she was teaching. Jody Hildebrandt got up. She was a little bit more defiant. She was a little bit more still sort of denying some of the things that were happening, had happened. So it's the state of Utah is odd because the judge doesn't impose the sentence. The parole board does. And so the judge sentenced them to each to 4 consecutive 1-year to 15-year sentences. But the judge doesn't decide how long the sentence is going to be. So they have to go before the parole board, apparently, and they determine how much time they'll be incarcerated. I wouldn't be surprised to see Ruby get less time than Jody. And if I had to guess, I would say 12 to 15 years total time is probably what they'll get. That certainly allows the Frankie children to grow to adulthood before they have to face the fact that their mother's out of prison. So Jody Hildebrand was stripped of her therapist license, of course, and so that case is wrapping up. There are quite a few cases that we haven't heard a lot on since. The Michael Vaughn case up in Fruitland, Idaho, the little boy that disappeared, and probably about a year ago, they dug up a neighbor's yard and cadaver dogs hit on it, but it appears that the body had been moved. They still haven't found Michael Vaughn's body. One of the tenants there in the home made some confessions, but she is also extremely mentally ill and has been declared incompetent, and the charges against her were dismissed while she is receiving some sort of restorative care. Lauren Matthias had her husband on her show to talk about what he knew about the case. But his information, I think, was fairly limited. You can find that on Lauren's channel at Hidden True Crime. So those are sort of all of the updates I've heard recently or found recently. There hasn't been any movement on, I have to go back through my notes, the young man who was dry wheat farming and disappeared, and it turned out that the homeless man was responsible for his death. They spent all summer last summer looking for his body, and it's never been found. And I haven't heard anything more about when because they did charge the vagrant guy, and I haven't heard anything more about when his trial might come up, but I will look it up. If you have cases that you would like for me to discuss, please let me know. And I will. We have Shanna Gardner's case is coming up. She's the one who, it's another murder for hire case. She got her husband to hire a hitman and kill her ex. So a little bit more like Adelson. And it's in Florida too. Jupiter, Florida, I think. And so she comes from a very wealthy family. They own a company that does crafting and rubber stamps and scrapbooking, that sort of thing, and came from a really wealthy family. And then and her ex-husband worked for Microsoft, so was a pretty interesting. Oh, somebody's asking me about Delphi. Let's talk Delphi. I did see that there are motions flying around, and I think the next trial is the 23rd or 24th. I can't remember now. I was watching Bob Motta earlier, and he's really got his thumb on the pulse at Defense Diaries. So if you really want deep dives into Delphi, check out Bob Motta. He's great. Bob and Allie, his wife. So they filed the prosecution filed a contempt action against the two lawyers. But it's clear that the prosecutor is really out of his depth because the filings are completely incorrect. He can't get where he's trying to go with what he's filed. So two lawyers on behalf of Baldwin and Rosie, who are the Richard Allen's attorneys, filed memos and opposition to the contempt action, and they filed a motion to dismiss the contempt action, and the judge just didn't have a hearing. Once again, summarily dismissed it and said that it's on for a hearing. So it'll be interesting to watch that hearing to see whether the judge is going to side with the prosecution, even with the pleadings being so defective. So we have a little time, so I'll get into that a little bit. In the law, there are two kinds of contempt. There is contempt motion that you bring in civil cases and contempt motions that you bring in criminal cases. Then within that, there's direct and indirect. So direct would be something that happened in the courtroom. Indirect would be violation of a court's order outside the courtroom. So in this case, the prosecutor filed an action for contempt against Baldwin and Rosie in Richard Allen's criminal case. And what all the experts are saying, which is, in my opinion, is correct, it is that Richard Allen is the defendant in his case. It is not Baldwin and Rosie. And that in order to have an action against Baldwin and Rosie, it needs to be filed in a separate criminal action. And the prosecution has not done that. The other thing they didn't do was they didn't specify whether or not their information that they filed against Baldwin and Rosie was a civil contempt or a criminal contempt. They're very different in the way they're treated. For one thing, if you are, because a criminal contempt, can result in incarceration. A civil contempt cannot. So there's no way to know, and that was pointed out in the oppositions to those motions, that there's no way to know what it is that the prosecution is seeking. But I thought it was interesting that the judge completely denied it, because it just continues to show her incredible bias against Baldwin, Rosie, Richard Allen, and a clear preference for the prosecution. So I am really hoping, what my thought was, if she continues to deny these motions and she denies dismissing this contempt action, which is so blatantly wrong and against the law, then I think they have got even more ammunition to ask the Supreme Court to get rid of her, to prove her bias, because clearly she is biased. Thank you, Polly-O, for the super chat. I appreciate it. Thanks so much. We love your support and appreciate it very much. So thank you. So it will be, I'm not supposed to say interesting. It will be riveting, I think, because I'm a lawyer, a law nerd, and I love those hearings that get into the weeds and really get down into the nitty-gritty of legal arguments. And I think that's where this one's going to go. I do think that there's going to be a lengthy hearing on it. Now, Rosie and Baldwin have already filed a motion to have those live streamed, to have the hearing live streamed. And the court hasn't ruled on that either. So we don't know at this point whether it will be live streamed. Now, I know that Bob Mata, he is in Indiana, and he's in Illinois, and the Delphi case is in Indiana. He's about 2 hours away, so he usually attends all the hearings, and I'm sure he will attend this one because he's as interested as I am in these legal arguments for the contempt action. So one way or the other, we will hear about what's going on, and we'll hear about what happens in that trial. I'm hoping it's live streamed, but we'll see. The judge had just approved a live stream of the hearing, the first live streamed hearing in the case on the day that Rosie and Baldwin were first disqualified. So that was part of the reason why they didn't fight harder, because the judge said to them, this is the first televised hearing. Do you really want me to go out there and embarrass you in front of all and in front of the world? So that was sort of her little, her power over them. I think that if she rules against them again, then I think their only recourse is going to be to file an original action with the Supreme Court. So as we talked about last time, when Baldwin and Rosie were dismissed, they filed filings in the case, and the judge refused to accept them. She refused to accept all of their filings, including recognizing notices that they filed that they were appearing on Richard Allen's behalf pro bono. And so the only way, because she was the stop, the only way that they could have that decision reviewed was to file an original case in the Supreme Court. Now, the Supreme Court allows that under very narrow rules. They were able to get the Supreme Court to take the case because there was no recourse. They were pretrial. Richard Allen's due process rights and his right to a fair trial were being trampled all over because of the judge. And so they were able to get the Supreme Court to agree to hear the case and to rule on their reinstatement. The Supreme Court refused to address the issue of Judge Gull. And she took that as a license to run all over the top of everybody. So the difference now is that Rosie and Baldwin are back in the case, and they can file actions in the case, and they have. So they have to get to the point where Judge Gull once again is the roadblock, and then they may be able to go back to the Supreme Court with an original action to have her removed. So every one of these motions that she summarily denies, every one of these hearings that she has where she's so blatantly biased, is more ammunition for them if and when they take the issue to the Supreme Court in an original action. So I hope that explains a little bit of it. It's such a convoluted case. There's also the issue of the prosecution not turning over all their discovery. And then when the defense finally asked and said, wait a minute, we don't have this. They said, oh, well, they were FBI interviews, and you have the written reports, which specifically say this isn't a verbatim transcript of the interview. For details, see the interview. But they said, well, you have a report, but unfortunately the interviews, the video was written over, and there's no copies of that interview. So I actually think that probably doesn't go anywhere. I think it's suspect, and I think that the prosecutor in this case is very suspect. But I'm not sure that that is a winning argument for the defense. However, I think they are continuing to make the argument, rightfully so, that Richard Allen's rights are being violated. So I'm anxious to see what happens in that hearing, and then see where Rosie and Baldwin go from there. One of the opposing memos that was written on behalf of Rosie and Baldwin is excellent. And, it definitely is written by somebody who knows their stuff. And so I'm a little bit anxious to see what happens in that hearing. Sorry, I just got distracted by a comment. I'll get to it when Jen puts it up. So shall we start taking some questions? Let's see if Jen has some questions. I know she's putting them all up. Oh, hi, Arwen. I'd like you to cover Daniel Robinson. Thanks and congrats on your book release date. Thanks so much. And Daniel Robinson is a young man. He was a geologist, and he was out outside of the Phoenix area. And if you've ever been to Phoenix, it's a very large city. But I'm telling you that you get beyond the limits of the suburban area, and it is desolate desert. Well, he was out doing some sort of survey work when he disappeared. There was absolutely no reason to believe that he was at risk, that he might take his own life, there was no suspicion of any of that. And bless his heart, his father has been searching for him it's been 3 or 4 years now. I was actually living in the Phoenix area when Daniel went missing, and there were a lot of groups out there searching for him, a lot of volunteers out to search for him, but he's never been found. And I will just say that the area he was in is an extremely inhospitable area. It is dry, and it is hot, and the terrain is rugged. And so, but I feel for his dad. I see him often on Twitter, X, and he was at CRIMECON last year, and he's done everything he can to bring attention to Daniel's disappearance. And there just are no answers. It's one of those cases where there literally are no answers. There are no clues. There are no inklings. It's just like he stepped off the face of the earth, and it's very, very sad. And his father is a very nice man and very devoted, and he just says, I won't give up until we know what happened. And it's sad. He was a young, well-educated young man just starting out his life, and with a career as a geologist. So, any other questions? How can we get access to the Google Drive for the crane pattern? So the address is in the show notes. Just copy that, cut and paste it into your browser, and it should pull up that Google document. It is sort of a copy of a copy, so it's not the greatest in quality, but the instructions and the printed patterns are on the back. I am going to do an instructional video. One of the things that's important to remind people who are not paper piecers is always to leave a 1/4 inch border, an extra 1/4 inch of pattern from the line, because that's your sewing line. Oh, okay. It says you need access. So I will, when I'm done with the show, I'll get in and make sure that that you all can get access to it. That's funny, because when I tested it, I cut and pasted the link and put it in my browser, and it popped right up. So I will double check that and make sure that you all have access to it, because it's going to be a fun project. So as I say, paper piecing is a little bit different. If you're not, it's a technique you may not be familiar with. And so this week, I will do an instruction video so that everybody sort of gets an idea of how to do it. It doesn't take very long to put up a little video that gives you some guidance on how it goes together. So, question: how does the parole board know when to sentence them? Oh, hi, Angela. You're talking about Jody Hildebrand and Ruby Franke. So what happens is the judge will enter a judgment of conviction on all 4 counts. He will enter the judgment saying that the plea agreement was for whatever sentence they received to be consecutive, meaning one after another. So they stack on top of each other. And it's interesting that Utah has a statute that says, first of all, says that concurrent, meaning running at the same time, concurrent sentences are the preference, and that in order to have consecutive sentences, a judge has to make some specific findings that the crimes warrant those consecutive sentences. The next thing that happened is that they already have done a pre-sentencing report. So the judge's judgment of conviction and the pre-sentencing evaluations will go to the parole board, and they will determine the sentence. I think Utah may very well be the only state that does that. In general, the judge is the person who imposes the sentence. So it's very odd. But they will be sentenced. They are going to run consecutively. The board can give them anywhere from 1 to 15 years on each count. My prediction in my crystal ball is that they'll probably get a total of 12 to 15 years. I could be really wrong. The other thing about Utah law is if you do the math, 15 plus 15 plus 15 plus 15 is 60 years. However, Utah has a statute that caps a maximum sentence for anything but murder at 30 years. So the maximum penalty that they could get would be 30 years. The minimum they could get would be 1 year on each count, which would be 4 years. So the sentence is going to be somewhere between 4 and 30. Like I say, my prediction is somewhere kind of right in the middle. So, good questions, though. I don't get why Utah does that, but it's Utah. Hi, Idaho Mom reports Daybell trial coverage. By the way, I'm assuming you're going to be at the trial, so we need to get our heads together when we're there. And drop me a DM and let's meet for coffee. Anyway, is Judge Boyce still going to be a Jersey? I think she meant jerk. To you at Chad's trial. I like him, except how he treated the good Lori. I was there and it was unjust. Well, thank you. I think it was pretty unjust too. However, I am still, I am definitely going to be in touch with the clerk of the court and have her confirm that I am allowed in the courtroom this time. And I do want to say, I have not been a fan of Judge Boyce from day one, but I am not going to be somebody who doesn't accurately report things and try and be as fair as I can be, because I think that's my responsibility. And I have to say that I think Judge Boyce got off to a very rocky start in this case. He was very green, as was everybody else in the case. And I think that his start was rocky. I do think that he did a very good job at Lori's trial. I have no criticism. I don't have any criticism about any of his rulings. The only criticism I had about Lori's trial was I thought her defense attorneys were asleep at the switch. I also think that you're going to see a much more vigorous defense for Chad. That said, Lori also really hamstrung her lawyers. She would not allow them to go down the it's all Alex or Chad's fault road. And I don't think you're going to see that for Chad. I think they're going to go out of their way and do everything they can to pin all of this on Lori and Alex. So Yeah, I intend to get a hold of the clerk of the court. She is a really nice woman, who I met in the run up to Lori's trial. And I will get a hold of Sandra and have her confirm for me through the proper channels that I am permitted in the courtroom. The other thing is going to be live streamed this time on the court's website. So I think there's going to be a lot less pressure on the courthouse. I will be renewing my motions for release of all the sealed documents the day that the hammer falls and he's found guilty. And we'll see whether or not the judge is going to put up a fight about that. That's really the only issue for me, is that he sealed things that were improperly sealed, shouldn't have been sealed. And now, once Chad's trial is over, I'm going to be very assertively getting those. The way the deal I have with my publisher at this point is that there will be some updating of chapters and in the manuscript, and update and additional chapters that I anticipate once Chad's trial is over. So I do still have a short window of time to make sure I get as much as accurate and as up to date as I can when the book goes to press. So yeah. Jane Blackbird. Larry Millette case in San Diego. Wife and mother May missing, no body. Murder charges filed. He hired spellcasters to make it so she got hurt so badly she would have to be totally dependent on him. Wow. I hadn't heard about that case, but I'm going to make a note of it because that sounds really interesting. And, I'm always interested in cases where there are people who are using the supernatural or claim to be using the supernatural, like the doomsday prophecies and those sorts of things. So that's really interesting. I will look that up, and I will have info for you. Gail Swift Fernandez, any update on Suzanne Morphew? There is not an update on Suzanne Morphew directly. There was a hearing recently, but it had to do with the suit that Barry Morphew has filed against the state for wrongful prosecution and false imprisonment. So if you recall, after Suzanne Morphew disappeared, the police arrested Barry Morphew. The state called had a bunch of expert witnesses they were going to call. They missed all the deadlines, did not turn discovery over to the defense when they were supposed to. There were massive, major discovery violations, so much so that the judge barred them from bringing any of those witnesses in, and that really basically gutted their case. So they dismissed the case against Barry Morphew. That was before Suzanne's body was found. However, they have not refiled any of those charges, and Barry Morphew has a suit against the city and the state and the district attorney. So, and that was the DA you think the DA in the Vallow case screwed up. The DA in the Morphew case, wow, that was a major mess. So I don't think that I don't foresee that he's going to be charged again. I see a little comment that says, how do I get a bracelet? There is an address in our show notes, and I'm sure that Jen will put it up toward the end of the show. And all you have to do is send me it's in the chat. See that? All you have to do is send me a self-addressed stamped envelope to the address that's in the chat. and I will send you a bracelet. I need to deal with the stack I have here next to me. I ordered a couple of little like swaggy things for CrimeCon, and I thought I'd tuck those in too if I when I sent the bracelets, but they haven't come in yet. So I think I ought to get on it and get your bracelets out to you. I think I have maybe 4 requests, but that address is still good and you can send. Rabbit holes. If possible, can you help explain what just happened in Colorado with prosecutors surrounding the case involving Barry Morphew? It was a bit confusing. Yeah, see, my understanding is what you saw was part of the civil case that Barry Morphew has filed against the prosecutors as well as the state. It doesn't have anything to do with criminal charges. It has to do with the fact that he has gone after them civilly for damages because of their what he is claiming was wrongful prosecution as well as false imprisonment. So, but I will go back and watch that. I saw it, but I was sort of in the middle of other things. So I will go back and watch that, and we'll do an update next week. And I will be able to give you a more thorough answer. Do you think Adam Montgomery's absence from court has an impact on the jury? As a juror, I'd wonder why he wasn't there and would probably think he was too dangerous or mentally unstable. You know, Dawn, that's a really good point. I think the judge will give an instruction or gave an instruction. And it kind of comes in at the same time that the judge gives the instruction that the defendant doesn't ever have to testify, that he has an absolute right to remain silent. And I'm sure that she's given them an instruction saying, you know, you cannot infer anything from his absence. But I'm sure that it's human nature to look over there and think, well, the only thing we've seen of him is photographs because his body's not in the courtroom. And I think that it's human nature to infer from that there is some reason why he's not there. And I think that was a real difficulty, a real sort of stumbling block for his attorneys, a setback for them when he decided not to come. But to be honest, it is a horrible case. The evidence is so beyond awful that I think it would be really difficult for any defense attorney to make a silk purse out of that sow's ear, to use an old adage. I mean, I think it was what attorneys would call, defense attorneys would call a slow and painful guilty plea. Because I don't think the outcome was ever in question. But he is entitled to his day in court. So, but I think the jury could infer that. Trisha the Trucker. Hi from Springfield, Missouri. I hope you're well, and I hope I just got here, so sorry if this is a repeat. Will the fact that Jodi was a licensed therapist hurt her and help Ruby for the parole board? You know, I think it does. I think if you heard her statement to the court, she was very clear that she felt that she was influenced in her actions by Jodi. We knew that was the case. We knew. And her attorney made the point that once she was arrested and was in custody, it was kind of like she got far enough away from Jodi to really think about what they've been doing and really internalize reality rather than her sort of delusional living in Jody's world. She admitted she was very paranoid. She didn't trust hospitals. She didn't trust law enforcement. She didn't trust anybody. And so I do think her attorney made the point that she had been very cooperative with the authorities and that she had cooperated with them against Ruby or against Jody. So I do think that that will help her. It will go a long way to help Ruby, and I think that it will hurt Jody. The very idea that she was not only that she was a therapist, but she was a therapist that was literally being recommended and financially supported by the LDS Church. She was on a referral list for bishops to give recommendations to their parishioners, and bishops always have a discretionary fund to help members of the church. And so a lot of times what would happen is a bishop would recommend that someone get therapy, and they would say, I can't afford to get therapy. And the bishop would say, the church will help you with that. And so Jody was literally being underwritten by the church. Her niece, Jessie Hildebrandt, was interviewed, and they said, she uses they and their pronouns. They said that they lived with Jody, that Jody did many of the same things to Jessie that were done to Ruby's children, binding them, starving them, working them for hours in the hot sun, those sorts of things. And one of her jobs when she lived with Jody was to do Jody's billing for her therapy practice. And Jessie's observation was probably 80% of the bills that went out were paid by the church, by a bishop's fund. And Jody was living in a $3 million home. So that tells you she was making a lot of money off the church. So it makes me think that Ruby will probably get a lesser sentence than Jody, and makes me think that that's going to be because she was so cooperative. So these are good questions. Ladybug Lady, how are your bugs? Question: does Adam M. have to be in the courtroom for the verdict or the sentencing? You know, I would say he needs to be in court for the sentencing at a minimum. I think he probably could refuse to show up for the verdict, but I think he needs to be. I mean, my reaction is he needs to be in the courtroom for sentencing. The reason being that when the judge imposes the sentence, it's a due process kind of an argument. He needs to be there to receive the sentence, to be on notice what the sentence is, but I guess it will be interesting to see whether the judge at that point, whether the New Hampshire law allows the judge to say he can stay in his cell. So yeah, it's an odd situation because in most jurisdictions, I think a judge would say you need to be in the courtroom even if you have to be brought in shackles and hogtied. But this judge didn't want that. Didn't want those optics, I think. Tiff Knox, yeah. If there are victim statements, he has to be there for that. I would say yes, he does need to be there for the victim impact statements. Um, I, I, I think that it would be a violation of victims' rights. Now, here's the thing: most states passed have passed either a statute or put it in their constitutions, a Bill of Rights for victims. So a lot of state constitutions have actually been amended to include a victim's Bill of Rights. In some states, it's memorialized in a statute rather than in the Constitution. But either way, I don't know of a state that doesn't have a victim's Bill of Rights. And one of those rights is to confront the defendant. So the judge is going to have to weigh his rights versus the rights of the victims. So that's a good point, Tiff. Guys, I'm getting dry here. Many, many good questions. Any last questions, or shall we wrap up? I want to, I wanted to, oh, Rosebud. Question: does the state need a death qualified attorney on the case for Chad Daybell? Yeah, this is a question we've answered before, but I will answer again. If you are given a court-appointed attorney, in order for the state to appoint you, you have to meet certain qualifications that are set by the state. And you have to have accomplished these things, done continuing legal education on death penalty cases, have been a second chair on a death penalty case, and you have to have some experience and some continuing education in the area of death penalty cases, because they're very death penalty cases are very technical. There are a lot of little technical hoops that you need to jump through in order to make sure that the death penalty conviction will hold up on appeal. So, and the assurance that your client's rights are protected. However, if you retain your own attorney and you pay that attorney, it's your responsibility to make to vet your attorney and to make sure that you are they are qualified to do the work that you're hiring them to do. So this was the point of contention for John Pryor. Now, John Pryor says he has the requisite experience and could have been death penalty qualified, but opted not to be because he wasn't taking state-appointed cases. It's a little perplexing to me why he didn't, when he knew that Chad was out of money and he was going to be forced to ask the court to let him withdraw. As it turned out, he sort of hemmed and hawed in that hearing, and the judge said, I haven't heard enough to make me want to let you off the case, and so you're on the case, and the trial's going to go forward in April. He is not required, because he is retained and not paid for by the state, he is not required to be death penalty certified. Now, at the hearing that where he asked to withdraw, he told the court that he continued to look for help from a death penalty qualified attorney, and that didn't happen because he couldn't find any. The question I'm talking about, the state of Idaho having death qualified attorney. Well, this is a problem throughout the country right now. There is a shortage of defense attorneys, and definitely a shortage of attorneys taking more complex cases. And that is because the states simply aren't, the compensation for defense criminal public defenders has not kept up with inflation has not kept up with their prosecutor counterparts. It's abysmal. And because of that, they can't attract people into the public defense, into doing public defense work. And regrettably, I mean, some of the attorneys that I worked with were really highly qualified, very good criminal defense attorneys, very experienced. But as we've been retiring, bringing new people on has been impossible, because somebody right out of law school looks around and said, well, I could go to work for the prosecutor where I get PTO and I get health insurance and I get a retirement and I get training and I get all these things. Or I can go to work for the public defender, make half of the amount of money, have to pay my own health insurance, fund my own retirement, and have to really be without the sort of training that makes for good attorneys. So it's been very difficult, and there is a real shortage of attorneys in all states. I know that there is a shortage of death penalty qualified state attorneys. Jim Archibald, who represented Lori Vallow, was just recently appointed to a kind of a gnarly death penalty case out in Eastern Oregon, or out in Eastern Idaho. Where am I here? And so he's already got that case. He couldn't have taken Chad's case anyway because he'd be conflicted out. But I do know that there's a real shortage. So no, the prosecution does not have to be death penalty certified. Oh, that's true. The prosecution doesn't have the same requirement that the defense does. And that's interesting. Because neither Lindsay Blake nor Rob Wood had ever tried a death penalty case, had ever tried a murder case when these cases happened. They were both very new to being elected as district attorneys, and they were living in a jurisdiction where murders rarely happen. So neither one of them had ever tried a murder case. So it's been trial by fire for them as well as for Judge Boyce. Because they had to learn on their feet. But that is the price you pay for being elected. Rosebud, question: will the state have to bring on another death qualified attorney in order to go forward with the case? No. The judge told John Pryor. The judge had approved a year ago in January. They had a behind closed doors session, and the judge approved paying a death penalty certified attorney to come alongside John Pryor. And John Pryor hasn't been able to find one, because I think at last count, there's about 25 on the death penalty roster. And you have to remember that not all of them are qualified to be lead counsel. A lot of them have qualified to be second chair, but they have to have at least tried a death penalty case as a second chair before they can be lead counsel. So it's all complicated. And at this point, John Pryor has not been able to find somebody. Now, he did say in the hearing where he asked to be allowed to withdraw that he had been earnestly searching, that he had someone who had applied to the state to be death penalty certified, but the state had not gotten back to him about whether or not they were going to approve this fellow. And so as time got shorter and shorter, it got less helpful. But Chad Daybell said he definitely was going to he was certainly going to continue to try and get this guy on. I don't know whether that's happened or not. So good questions, though. And, it's hard to say. Jane, anyone know info on James Crumbly's hearing today? I didn't see it. I think it was a status conference for his upcoming trial, was my understanding of it. But I'll go back and double check that to make sure that we didn't miss anything. But my understanding was it was just a pretrial conference ahead of his trial coming up. And her sentencing is coming up. So there's a pre-sentence investigation that needs to be done. And like in Chad and Lori's case, you know, I think the prosecution would probably offer him this, whatever she gets, and there may be a plea. So I think they're kind of waiting on that. But I didn't see anything that would indicate that that it was any momentous hearing. But I'll refresh my feed just in case I miss something. So I don't like to particularly to get political, but there are some interesting arguments, interesting legal issues that are coming up in former President Trump's hearings. So the interesting legal issue of presidential immunity is kind of hanging out there. The appeals court said you don't have absolute immunity. He's appealed that to the U.S. Supreme Court, and there is no indication yet whether the U.S. Supreme Court is going to take it up. The Supreme Court has the option not to grant certiorari and to say we don't believe that there's a federal issue that rises to the level of us hearing it. Clearly, the issue of presidential immunity is a federal question. So we'll see what happens with that. I don't know whether you all are interested in my talking about those things. I don't want to make the channel political. I don't want to get into, you know, the merits of any of those cases. But I think there are some interesting legal issues that have been raised in pretrial motions and those sorts of things that I think would be interesting to talk about if you're interested. So let me know. I thought about this earlier and thought that I should mention this. So Kristen, I'm glad you brought it up. I did hear that the Petitos and the Laundries settled today, like this afternoon. They were in a mediation and they were able to reach an agreement. I think everyone was pretty surprised because I think when some of the information came out in the depositions, the Petitos were pretty adamant that they were going to go forward because they wanted the Laundries held accountable. But let's remember, this was a civil suit. The law on intentional infliction of emotional distress is kind of smushy. And I think that there was at least some chance that the Petitos were going to lose. I think that there was enough of a threat that it made sense for them to settle. Now, the Petitos always said it wasn't about money. It was about the Laundries coming clean about what they knew, when they knew it, and taking responsibility for the fact that they gave them a tremendous amount of false hope that Gabby was still alive, even though they knew that she was dead. Sorry. The question is whether the statement that they made, which was, we hope that Gabby will soon be reunited with her family, was enough of a, I don't know, inflammatory, passionate statement that it caused that level of emotional distress. And how, in that situation, do you draw a distinction between the emotional distress of knowing that your young adult daughter has likely been murdered? how do you distinguish that from the emotional distress of them saying, we hope she's reunited with her family soon? I think that it was a real question, and I think it was I'm glad. I think it was smart of the Petitos to resolve it with some kind of a settlement. Now, I know that the Petitos also filed against Brian Laundrie's estate, such as it was, and I don't. I believe that they got something from Brian's estate for wrongful death. I don't know. I mean, these are not deep pockets. These are not people who are millionaires and billionaires. And there's not, unlike the political cases that are going on right now, there's not $400 million to award or $86 million to award. So I think it was wise all the way around for them to settle the case. Because I think there were some real questions about whether or not they could prevail. And litigation is expensive. And we don't know whether what the agreement was with the attorney that brought the civil suit. So we don't know, but they're usually taken on a contingency. And so, first of all, you're looking at the fact that the Petitos have nothing. I mean, the Laundries have very little beyond a home. And the best thing that was going to happen was that the Petitos were going to force them into bankruptcy. Then it would be up to the bankruptcy court to decide whether or not their intentional torts survive bankruptcy. That's a question for the federal bankruptcy court. So, I mean, it could have gotten very, very convoluted, and I'm glad for both of them, because I'm not sure there was a great deal gained by suing the Petitos suing the Laundries. But I completely understand the emotion of it, the emotion of saying, you withheld that evidence from us. You withheld information that you knew. You helped him lie to us and disguise what really happened to our daughter. And we're pretty pissed off about it. And I can see that. The question is whether or not the court has the power to offer recourse. This is always a question when you go to court. It's easy to say, well, I'll just sue. But the truth of the matter is that courts are often not really designed for what it is that you want them to do. I think there's no clearer example of that than in divorce court, because you go to court and you are now dissolving this most personal and intimate relationship. You're asking the judge to help divvy up your assets and your liabilities. You're asking the judge to tell you what to do about your children, to tell you when and where and for how long you can see your kids. And those are not necessarily things that the court is really good at deciding. So I think that it is important to remember that some remedies that are available in court are probably not the best way to deal with your business. I think sometimes the people expect that a court is going to rule on emotional issues and to be truthful. The court isn't really designed to be ruling on emotional issues. The court is really designed to rule on the law and on money and on corporations and on criminal defendants, where the law is more about the facts than it is about the emotions. And so I think that's where the Petito case kind of lacked. And I am glad that they were able to reach a settlement so both of those families can move on. because it's important to remember they both lost their children. And, I'm not going to defend Brian Laundrie. I think what he did was reprehensible. And he, like Fotis Dulos, took the coward's way out, and refused to actually be accountable for what he did. But, I hope that a more qualified judge than I will be judging Fotis Dulos and Brian Laundrie for their actions. I think I understand how the Petitos felt like they couldn't get justice because Brian Laundrie took that away from them by taking his own life. But I don't think there's any way. I don't think there's any way to get where the Petitos thought they wanted to go through the courts. So, good questions, guys. I want to remind you all that I do read all your comments and the chat. I do go through it all and look at all the questions and all of the comments, and I appreciate it. Jen wants to know, do the Petitos have a case against the police that pulled them over before she passed? I believe so. I believe that they do have a cause of action against the police. For one thing, I saw that their contention was that Gabby was the aggressor. And I think that that was short-sighted. I think that that was jumping to a conclusion that perhaps wasn't accurate. And I realized, they were doing an investigation by the side of the road. They did recommend that they separate, but that's not always very effective either. I think that they should have done a better job of investigating. They definitely should have gotten Gabby away alone and had an earnest conversation with her about what was going on, because we know now that there was domestic violence going on, that Gabby had been victimized by Brian, and that she was afraid of him. And so it was a horrible, unfortunate situation all the way around. And I do think that, and I think that is in the works, is my understanding from what I've heard. I mean, I'm not inside the case, but it would make sense for them to bring suit against the police, because had the police arrested Brian for the domestic violence, I think Gabby would be alive today. So. Kristen, sorry to circle back to an earlier topic. That's A-okay with me. I don't mind a bit. But Arizona has been pretty transparent with info about Lori. What do you think could be in those 88,000 pages of new discovery? So my understanding is a big chunk of it is an FBI CAST report. CAST is the FBI's unit that does cell phone, it's not even triangulation, but they do cell phone analysis. It was the information from a CAST report was used in Lori's trial. So it's not really new information. But I think that in the form that it was received, it is information they haven't received in that form before. I think they will do much the same as they did in Lori's case. They'll put it on a map so it makes some sense, and they'll do sort of that interactive, here's a thing that they did before. I think that was pretty effective in showing where the cell phones were, the text messages that were sent, the traffic, the timing. They created their timeline with the phone pings. And so my understanding is that the bulk of that has to do with the FBI's CAST report, and that is information that they've had, is just in a different format. So it may not be as voluminous and overwhelming as we think. And, remember that there were thousands of emails, thousands of text messages, tens of thousands of text messages. And all of those have to be gone through, because you may go through 100 text messages of what do you want for dinner, and then come across a little nugget, and they're buried in there. So it's important to go through all those things and to identify where those bits and pieces are. And there's no question the prosecution has had much longer to delve into and digest all that information. So I saw a note in the chat that said that Linda missed a notification. I'm hearing that even if you are a subscriber, a current subscriber, sometimes you don't get notifications because YouTube turns off notifications for you. And I've heard it happens in the case where videos are demonetized because of because of content. We haven't had that problem. However, I think in an abundance of caution, you might want to go check and make sure that your notification bell is on, because I think that has been happening a little bit. So. Any other questions before we wrap up? Hi, Sharon. Why do some trials have pre-sentencing investigations and others, like Murdoch, go straight to sentencing? This is a really good question. And it does vary from jurisdiction to jurisdiction. In some jurisdictions, a pre-sentence report is mandatory on certain felonies, particularly on capital cases. In other jurisdictions, it's not. So we've seen a fair amount of pre-sentence investigations recently in Vallow, Daybell, in Hildebrandt and Frankie. So sometimes it's discretionary with a judge. A judge may say, I don't need a pre-sentence report. I know what I need to know about this defendant. So, I mean, a lot of the information that would have been in a pre-sentence report for Murdoch was on the table already. We knew he didn't have any prior offenses. We knew he had drug issues. We knew, we knew a lot of what would be in a pre-sentence agreement because it had already come out at trial. And so Judge Newman decided he didn't need a pre-sentence evaluation. On the other hand, I think pre-sentence investigations often help defendants because they flesh out a defendant beyond what the judge might know in trial. So in some jurisdictions, it is mandatory for certain complex felonies, for all of the big ones: murder, rape, arson, those that could result in lengthy sentences. And then in some states, it's discretionary with the judge. If a pre-sentence investigation is requested by the defense, then I think they have to do one. But if the defense doesn't request it, then I think in those discretionary states, it's up to the judge. These are all very good questions. I want to thank everybody for being here. I want to thank you once again for the tremendous support that I have gotten yesterday and today over the live link for my book. I'm beyond excited about it. I appreciate all of you for your support and how excited you are all. I'm pretty proud of it, so I'm anxious to see what people think about it. I want to remind everybody that we're working on a book launch team, and that will give you some access to some things that you might not have otherwise in return for posting reviews on the book, including access to a digital copy, an early digital copy. So we're going to be launching that, I hope, next week, as soon as I can get my IT guy moving. We're going to launch that next week, and I hope that you'll join us and that you'll join that group. It's for the first 100 people who sign up, so be looking for the links. They'll come out both here on YouTube and in my newsletter as well. We'll send out a special newsletter about it. The other thing is, if you all think that it would be helpful for me to put the quilt pattern in a newsletter and send it out, let me know, because I can always do that. I will check the Google link as soon as we're finished here this evening and make sure that you all have access to the pattern. Please, please, please email me and let me know. Don't wait, email me. And you all know the email's in the show notes too. It is info@thelorivallostory.com. And let me know if you're running into problems, because we'll get it to you one way or the other. I mean, if I have to snail mail them to you, I will, because I want everybody to participate. I'm very excited for what folks will come up with. Any color on a black background works perfect. So I think it's going to be amazing, and I'm excited to see what y'all come up with. So as soon as we're finished, I'll go check that Google link, and I'm wishing you all have a great week, and I will see you here next week. With that, I'm going to say good night.